Good morning, everyone. This meeting is called to order. Mr. Trobman, has anyone signed up for public comment?
Good morning, Commissioners. Les Trobman, General Counsel. We have one person who did register, Rashim Mohammed. Mr. Mohammed, if you're there, go ahead, unmute yourself and please begin. Not there. I don't believe he's on the line, so that's what we have. Thanks.
All right. Thank you, Mr. Trobman. Good morning, Ms. Miller.
Good morning, sir.
All right. No cases to reconsider under agenda item 3.
Correct.
On tax liability cases on agenda item 4, we have 1 tax case on docket 41, on docket 41, and 4 on docket 42.
Yes, sir, that is correct. For docket 40, it's case number TD-22-024-0822. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
I agree with staff recommendation.
For docket 41, it's case number TD-22-014-0522. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I disagree with staff's recommendation. I do not agree that staff recommendation that the Cowboys are independent contractors and not in employment. The employer exercises control over the work performance of the Cowboys by setting deadlines and tracking the cattle headcount. There is no significant risk of loss to the Cowboys because they are assigned a specific job and paid an agreed upon fee for the work. Finally, the services performed by the Cowboys are integral to the employer's business. As such, these workers are employees under the direction and control of the employer.
I agree with staff recommendation.
Short form dissent.
yes, sir. And on docket 42, the first case is TD-21-043-1221. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
Mr. Chairman.
I agree with staff recommendation.
Second case, TD-21-044-1221. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
I agree with staff recommendation.
Third case, TD-22-022-0722. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
And the final case is TD-22-023-0722. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you.
We have no fair housing cases on agenda item 5. On agenda item 6, we have 1 pooled wage claim case on docket 40, none on 41 and 42.
Correct. The one case pulled for docket 40 is case number 21-055072-0. Commissioner Alvarez,
The decision is not correct. Although it appears that the claimant worked additional hours for the employer during her employment that were not paid, the evidence provided is insufficient to determine the number of hours to award wages. Regarding the work performance, or correction, regarding the work performed after her separation, the claimant has provided sufficient evidence to establish she worked 22.5 hours for the employer preparing documentations at their direction. The employer asked the claimant to provide documents they knew were not complete. The employer knew or should have known she would have to work to provide these documents. The employer is not entitled to request the claimant perform work after her separation without compensating her. Although the employer asserts their attorney informed the claimant not to perform work after August 4th, 2021, the letter provided is updated and still instructs the claimant to submit documents they know are not complete. The claimant is entitled to payment at her regular rate of 22.5 hours she worked completing items at the employer's instructions. The claimant rate was $53 per hour, and she is entitled to $1,192.50 for the work. Regarding the unauthorized deductions, the employer deducted $437.25 from the claimant's final check for past overpayments. The employer asserted they had a deduction authorization, but all they provided was a direct deposit authorization. That authorization also allowed the employer to adjust or reverse deposits to the claimant's account, not to make deductions from future pay. If the employer wants to make corrections to deposits, they would attempt to do so, but they are not entitled to take extrajudicial deductions from her later checks. the claimant is entitled to $437.25 in unauthorized deductions. Reversed, the claimant is entitled to $1,629.75 in total gross unpaid wages.
The AT decision is supportable. The documentary evidence and the claimant's own admissions during the appeal hearing show that her claim for additional wages was based on administrative work she allegedly performed prior to her resignation, but which she omitted from any reports or timesheets, even though she had asked for and received permission to bill for other such time. Her explanation for why she did not previously tell the employer about the work was not credible or consistent. In addition, the claimant acknowledged that her list of unbilled tasks had several errors, including billing twice for the same work. Finally, the list of alleged work included emails written by the claimant to the employer regarding personal disagreements. She also claimed wages for some alleged work after her resignation, even though much of it consisted of time spent arguing with the employer's attorney about documentation of her work, and the other part of the alleged work was unnecessary and unsolicited by the employer, since the employer only needed for the claimant to turn over the notes she claimed to have made during billable sessions with clients. Turning over those notes should not have required more than a few minutes, and she should have done that prior to her resignation. The deduction from wages was authorized in writing and was for a wage overpayment that the claimant admitted she has received. Accordingly, we should affirm the AT decision. The employer owes no additional wages to the claimant.
Affirm the AT wage claim dismissed, no wages owed.
Short form dissent.
Yes, sir. Have your short form dissent. So those were all the cases pulled for additional discussion on dockets 40, 41, and 42. You should have received the wage claim short form dissent list for those three dockets.
I move we accept staff recommendations on the remaining wage claim cases on dockets 40, 41, and 42.
I second the motion, except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 40, 41, and 42.
And I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for dockets 40, 41, and 42.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases. Please proceed when you're ready.
First, beginning with docket 40.
Case number 2837418, Commissioner Alvarez.
The decision is not supportable. The AT dismissed the claimant's appeal as late when the hearing packet clearly contained a copy of the claimant's timely appeal dated February 10, 2021. Additionally, the AT failed to consider assuming jurisdiction over any allegedly late appeal to the open period ability and availability issues under Rule 32I3, which denied the claimant an opportunity for the ineligibilities to be closed within his benefit year. The appeal should be deemed timely and a ruling issued on the merits. Regarding the ability issue, the claimant presented a doctor's note indicating that he was released to return to work as of November 17, 2020. The claimant was also available to work, but the employer did not have any hours for the claimant because the business closed due to the pandemic and was slowly reopening. The claimant returned to work for the employer in February of 2021 and worked the hours he was offered through April 2021. The claimant was able and available to work since November 17, 2020. The claimant was available to work beginning December 13, 2020 and able to work beginning January 24, 2021. The overpayment should be reversed. Set aside the AT, the claimant filed a timely appeal to the determinations dated February 3, 2021. Reverse, available to work beginning December 13, 2020. Able to work beginning January 24, 2021, no overpayment. In the alternative, I would agree to rehear the case to enter the claimant's doctor's note and paycheck stubs into the record.
We should dismiss the claimant's CA appeal as late because he did not file a timely appeal to the AT decision. Although the claimant's appeal to the commission was late, per Commission Rule 32I3, since the case involves periods of open ineligibility, the commission can take continuing jurisdiction 14 days prior to the date of the late appeal. Albeit the case, the claimant provided conflicting information about his ability and availability to work. Since there is insufficient evidence to close the ineligibility periods, the ineligibility period should remain open. Hence, we should dismiss the claimant's CA appeal as late and leave the underlying appeal tribunal decision in full force and effect.
Lake Commission appeal, the AT decision remains in full force and effect. Memo in accordance with staff recommendation.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2869036, Commissioner Alvarez.
The decision should be reversed. The claimant did not receive the first AT decision before the appeal deadline because it was sent to an incorrect address. On December 21st, 2020, the claimant's address was updated by a commission representative to an incorrect address. Representative incorrectly changed part of the claimant's address to lot 58 instead of lot 5A. When the claimant appealed the determination on January 22nd, 2021, she noted on her appeal that her address was lot 5A, but her address was not corrected. Nothing in the record indicates that the claimant ever verified the incorrect address used in the AT decision. Since the AT decision was mailed to an incorrect address due to commission error, the timeframe for filing the appeal did not begin until the actual date of receipt by the claimant. Deem timely and resubmit.
We should affirm the appeal tribunal decision. Concerning the late petition to reopen, per agency records, the claimant had previously verified that her address on the AT1 decision was her correct and accurate address of record. Since the claimant failed to update the commission with her correct address, and because there are no good cause exceptions to the timeliness rules, we should affirm the appeal tribunal decision. Untimely petition to reopen, voluntary leaving, no chargeback.
Reverse the AT, timely petition to reopen, resubmit.
We will resubmit the case.
Case number 2939211, Commissioner Demerson.
We should modify the appeal tribunal decision. First, I do not dispute the good cause finding. However, as to the job separation, the employer's fact-finding statement and the employer's appeal, both to the AT1, provide that the claimant was discharged for having an inappropriate and improper relationship with the general manager. Because the preponderance of the available evidence established that the claimant mismanaged her position of employment, we should modify the AT decision. The employer did not have good cause for its non-appearance, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer has provided no evidence to establish good cause for missing the prior hearing regarding the separation. Documentation available supports the decision finding the claimant qualified for benefits. The claimant was discharged for an alleged policy violation. However, no evidence was provided to prove the allegation. Further, after discharge, the employer wanted the claimant to work at another location. If the violation was so serious as the warrant discharge, it would be illogical for the employer to attempt to rehire her at another location. The claimant was discharged for reasons other than misconduct. Affirm the AT, no good cause, no misconduct, chargeback.
Affirm the AT, employer did not establish good cause for AT1, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 2970087, Commissioner Alvarez.
The decision is not correct. Although the claimant was informed by the employer that there was going to be a hearing, she did not receive the hearing notice. Simply being informed a hearing would take place is not sufficient notice. Additionally, the hearing could not have been conducted as the claimant had not received the hearing hearing documents, and this case involved a separation. The claimant had good cause. Reverse the AT, good cause, and resubmit.
We should modify the appeal tribunal decision. First, I do not contest the validity of claim issue. Concerning good cause, although the claimant alleged that she failed to receive the hearing notice, the employer provided sworn testimony that they had advised the claimant about the date and time of the AT hearing. Although the claimant acknowledged the employer's statement, she did not thereafter contact the commission to inquire about the hearing. Finally, when the hearing officer questioned the claimant about her failure to attend the hearing or to contact the commission, the claimant alleged that she just forgot about it. Since the claimant failed to present credible and persuasive evidence that she was prevented from appearing at the AT1 hearing due to circumstances beyond her control, the claimant did not establish good cause for missing the AT1 hearing. Concerning the job separation, the employer discharged the claimant after she repeatedly failed to follow the employer's instructions about training a new employee. Since the claimant was repeatedly warned about her performance, but thereafter continued to be insubordinate at the workplace, the claimant's conduct constituted mismanagement of her position of employment and was misconduct connected with the work. Hence, we should modify the AT decision. The claimant did not have good cause for missing the AT1 hearing. Valid initial claim, misconduct, no chargeback, sever adequate employer response.
Reverse the AT. Claimant established good cause for AT1. Resubmit.
We will resubmit this case.
Case number 2998235, Commissioner Demerson.
The appeal tribunal decision should be modified. First, I agree that the employer had good cause for its non-appearance due to the hearing being scheduled verbally. As to the job separation, the employer's account should not be charged. The employer provided testimony across 2 hearings that, when combined, support the conclusion that the claimant quit while there was work still available. There's no such evidence to establish that working conditions were intolerable. As such, the job separation was a result of a voluntary quit without work-connected good cause. We should therefore modify the AT decision. The employer had good cause for its non-appearance, no chargeback.
The AT2 decision should be affirmed. I do not contest at the conclusion that the employer established good cause for the non-appearance at the AT1 hearing. On the merits, the employer claimed that the claimant failed to report for reassignment, but also acknowledged that the claimant was not a temporary worker. The claimant apparently was involuntarily separated for non-disqualifying reasons. The employer has not provided any basis to conclude that their account should be protected from chargeback. Affirm the AT, good cause for their non-appearance at AT1, charge the employer's account.
Modify the AT. Employer established good cause for AT1. No chargeback.
Short form of dissent.
Yes, sir, Commissioner Alvarez.
Case number 3039641, Commissioner Alvarez.
Regarding the good cause, the claimant has consistently provided that he was unable to attend the hearing because he was dealing with a medical issue involving his son's ear. Whether the hospital visit was scheduled or an emergency is irrelevant to the issue of good cause. The claimant has good cause, and the case should be resubmitted for merits. Even if the claimant did not have good cause, the available record shows he was fired for reasons other than misconduct. The claimant was discharged for joking about what he would do if anyone tried to take his canine partner. Statements and evidence show that other officers present took it as a joke. One of the officers who reported his comments apparently didn't find them to be a real threat because he waited over 5 hours to report the comments. Modify the AT, no good cause, no misconduct, chargeback. Boyd AR.
We should modify the appeal tribunal decision. Concerning the good cause issue, the claimant did not attend the AT1 hearing due to a medical appointment. Although the claimant testified that the appointment arose from an emergency situation, when confronted about the statement, the claimant thereafter changed his stance and alleged that the medical appointment was pre-existing and that it was scheduled months in advance. Finally, the records show that the claimant did not request to reschedule the AT1 hearing prior to the date of the hearing. Since the claimant failed to provide credible and persuasive evidence that he was prevented from attending the hearing due to circumstances beyond his control, the claimant did not have good cause for missing the AT1 hearing. Concerning the job separation, the claimant was aware of the employer's policy, which prohibited actions that were threatening, demeaning, or that were in violation of the law. The claimant was terminated when he made a comment alleging his intent to inflict serious bodily harm on others. Since the claimant was aware of the employer's policy, but thereafter continued to engage in prohibited conduct at the workplace, the claimant's conduct constituted mismanagement of his position of employment and was misconduct connected with the work. Hence, we should modify the appeal tribunal decision. The claimant did not have good cause for missing the AT1 hearing, misconduct, reimbursing employer not billed, sever the adequate employer response issue.
Reverse the AT. Claimant established good cause for AT1. Resubmit.
We will resubmit the case.
Case number 3044654, Commissioner Alvarez.
The claimant missed the hearing due to delayed receipt of the hearing notice. The initial claim was filed with an effective date of April 4, 2021. The claimant was approved for benefits and stopped filing claims after October 3rd, 2021, because he had exhausted his benefits. Despite the employers filing a timely appeal to the determinations dated April 22nd, 2021, the hearing was not set until 11 months later on March 15, 2022, and the claimant was unaware that the employer had filed an appeal. When the hearing notice was mailed, the claimant was out of town caring for his ill mother and did not receive the notice in a time to participate. The claimant filed a timely petition to reopen and should not lose his ability to testify in his case, simply because there was a lengthy delay in scheduling the employer's appeal for the hearing. The claimant established good cause for missing the hearing. Reverse the AT, good cause, and resubmit.
The appeal tribunal decision should be modified. First, I agree that the claimant filed a valid claim. Regarding good cause, the claimant did not appear for the hearing because he was not checking his mail. Since this was a circumstance that was within the claimant's power to control, he did not establish a good cause for his non-appearance. As to the job separation, the AT decision is supportable. The employer testified that the claimant received a final warning for not filling out the appropriate forms associated with certain cells. Nonetheless, the employer testified that the claimant committed the same policy violations hours later. Accordingly, work-connected misconduct was established. We should therefore modify the AT decision. The claimant did not have good cause for his non-appearance. Valid claim, misconduct, no chargeback, sever adequate employer response.
Reverse the AT, claimant established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3046858, Commissioner Demerson.
We should modify the appeal tribunal decision. First, again, I agree with the finding that the employer had good cause for missing the second hearing. Concerning the first hearing, the employer testified that although it planned to attend, a customer emergency prevented the employer from participating. Because this was a circumstance beyond the employer's power to control, the employer has established good cause for its non-appearance at the AT1. Accordingly, we should modify the AT decision. The employer had good cause for missing the AT2 and the AT1. Resubmit the case for merits testimony.
The AT2 decision is supportable. I do not contest that the employer established good cause for the non-appearance at the AT2. As the employer's non-appearance at the AT1 hearing, the employer chose to address routine matters rather than participating in the AT1 hearing. The employer did not establish that their non-appearance was due to unforeseeable or uncontrollable circumstances. Finally, record before AT1 established, the claimant was discharged for reasons that did not constitute misconduct. The claimant was discharged for alleged acts of dishonesty that the claimant credibly denied and for which the employer failed to provide firsthand evidence. Affirm the AT2, employer had good cause for the non-appearance at AT2. Employer did not have good cause for the non-appearance at AT1. No misconduct, chargeback.
Modify the AT, employer established good cause for AT2 and AT1, resubmit.
We will resubmit this case.
Case number 3047271, Commissioner Alvarez.
The AT3 decision in this case is not supportable. The claimant was not provided an adequate opportunity to participate at the AT2 hearing because the hearing officer shut down the first setting of the hearing with 45 minutes left for no justifiable reason. If the time for the first setting of the AT2 hearing had been used correctly by the hearing officer, the claimant would have had a sufficient opportunity to provide all the relevant evidence without need for a continuance and without now having to show good cause for missing the second setting. Additionally, the claimant missed the second setting of the AT2 hearing because he was out of town due to the death of a family member. We should reverse the AT3 decision on good cause and resubmit the case on merits.
The appeal tribunal decision should be affirmed. Regarding good cause, the claimant was advised that the hearing packet for the AT2 continuance would be mailed to him. Nonetheless, the claimant did not check his mail to receive the hearing packet in a timely manner. Since this was a circumstance that was within the claimant's power to control, he did not have good cause for his non-appearance. As to the job separation, the claimant was fired for directing profanity towards a bank teller. Since this was done while making a deposit for the employer, the claimant's behavior could have damaged the employer's reputation with the bank. Moreover, the employer stated that it had warned the claimant previously about being rude and disrespectful to coworkers. Since the claimant engaged in activity that would have negatively reflected on the employer, and since such activity was prohibited by employer policy, the claimant's actions constituted work-connected misconduct. We should therefore affirm the AT decision. The claimant did not have good cause for his non-appearances misconduct.
Affirm the AT, claimant did not establish a good cause for AT2 or AT1 misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3057803, Commissioner Alvarez.
The AT2 decision is not supportable. The claimant became aware of the AT1 hearing while she was out of the country. She wanted to participate in the AT1 hearing, but was unable to do so because she could not call a 1-800 number from her location outside the U.S. The claimant was prevented from participating in the hearing by external circumstances and should be given a good cause for the non-appearance. Reverse the AT2, good cause, and resubmit.
The appeal tribunal decision should be modified. The claimant missed the appeal hearing due to personal reasons. As such, the claimant did not have good cause for her non-appearance. As to the job separation, initially, the claimant was able to meet the employer's job expectations. However, the claimant's work performance thereafter deteriorated due to unknown reasons. In addition, the employer's testimony reflects that the claimant admitted she had a lot of personal issues going on. Because the claimant's performance declined due to unknown reasons that appear to be personal, her failure to improve was mismanagement of her position of employment. We should therefore modify the AT decision. The claimant did not have good cause for her non-appearance, misconduct, no chargeback, sever adequate employer response.
Reverse the AT. Claim established good cause for AT1. Resubmit.
We will resubmit this case.
Case number 3090697, Commissioner Demerson.
The commission should conduct a rehearing in this case. Although the employer's investigation revealed that the claimant's job separation resulted from her violation of the employer's no fraternization policy, the hearing officer did not adequately question the witness nor develop the record about the nature of the claimant's policy violation. Since the record shows that the claimant was aware of the employer's policy and because the parties were insufficiently questioned about the claimant's alleged violation and the terms of the employer's investigation, the commission should conduct a rehearing to question the witness and develop the record about the claimant's job separation.
The notice of initial claim was properly delivered to the employer via sides per their request on July 24, 2020, before a paper copy was mailed to the employer on September 28, 2020. While the employer indicated they were never signed up to receive notices and sides, commission records reflect the employer was receiving sides notices as of June 1st, 2020. The employer's response was due on August 7, 2020, but the employer failed to respond until April 21st, 2021, which was late. As such, we should find that the employer's protest to the IC notice was late and leave the separation determination dated August 21st, 2020 in full force and effect. Late employer protest, no misconduct. Even if the employer's protest was timely, the appeal tribunal decision regarding the separation should be affirmed. The employer's allegations that she quit are not supported by the record. The claimant denied quitting under oath, and the employer's secondhand hearsay evidence that the claimant allegedly verbally quit is insufficient to prove that the claimant quit. The claimant also made attempts to clarify her status with the HR department. The employer initiated the separation by sending the claimant an email terminating her employment, and the employer has the burden to prove the separation was due to misconduct connected with the work. While there was a vague allegation that the claimant violated the employer's non-fraternization policy, no specific details of the final incident have been provided, and the claimant has denied any such allegations under oath. The employer has failed to provide or prove that the claimant was discharged with misconduct connected with the work. Affirm the AT, timely protest, no misconduct, chargeback.
From the AT. Timely employer protest. No misconduct. Chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3118873, Commissioner Demerson.
The appeal tribunal decision should be reversed on timeliness. The employer testified that it never received the TWC document in question and that it checks its mail every day. This testimony was uncontested, provided under oath, and should be identified as credible and persuasive. Accordingly, we should reverse the AT decision on timeliness, timely employer appeal, resubmit for merits testimony.
The appeal tribunal decision should be affirmed. The determination was mailed to the employer's correct address record and not returned to the commission. The employer failed to provide credible and persuasive testimony of non-receipt and failed to rebut the presumption of receipt. Since the employer's appeal was filed more than 14 days after the determination mailing date, we should find that the employer's appeal was late. The determination should be left in full force and effect. Affirm the AT, employer appeal not timely, no misconduct, chargeback.
Reverse the AT. Timely employer appeal. Resubmit.
We'll resubmit this case.
Case number 3149797, Commissioner Alvarez.
The AT should be modified. The claimant was absent from work because he was exposed to COVID and was quarantining while he awaited a COVID test result. He believed he was following the employer's COVID policy by returning to work once he had a negative test result. The employer claimed that he did not need a doctor's note but no policy was presented indicating this. The claimant acted in good faith by quarantining until he tested negative and then returning to work with his negative test results. He should not be punished for making a responsible public health choice to not risk exposing coworkers. Modify the AT, no misconduct, no chargeback due to disaster.
The appeal tribunal decision should be affirmed. The claimant was discharged for excessive attendance violations. The claimant had been warned that his job was in jeopardy due to his absenteeism. And nonetheless, the claimant continued to disobey the employer's attendance protocols. As such, the claimant's actions constituted work-connected misconduct, and we should affirm the AT decision, misconduct, no chargeback. However, in the alternative, because many of the events that contributed to the claimant's termination stem from the pandemic and the employer's protocols associated therewith, I would also support a vote for no misconduct, no chargeback disaster.
Affirm the AT, misconduct, no chargeback.
You want to
You
go
agree
with your
with the chair?
primary vote? Yes, sir.
Thank you.
So the majority vote is affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3165770, Commissioner Alvarez.
The AT2 decision in this case on the good cause issue is supportable and should be affirmed. The claimant testified that she never received the notice of telephone hearing for the AT1 hearing and missed the hearing as a result. There was sufficient basis on the record to support the AT2 conclusion, and we should not substitute our assessment of the evidence for that of the hearing officer. Affirm the AT2, claimant had good cause for the non-appearance at AT1 and resubmit for merits.
We should reverse the appeal tribunal decision regarding good cause. The claimant's new job did not prevent her from participating in the hearing. She testified that she missed the hearing because she overlooked or discarded the hearing notice. Because the claimant did not credibly and persuasively rebut the presumption of receipt, she failed to establish good cause for her non-appearance. As to the job separation, the employer's testimony established that the claimant quit in response to a reprimand. As such, the claimant quit without good cause connected with the work. We should reverse the AT decision. The claimant did not have good cause for her non-appearance, voluntary leaving, reimburse an employer not billed, sever the adequate response issue.
Affirm the AT, claim established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3176637, Commissioner Alvarez.
The decision is not supportable. The claimant quit because his job was contributing to his medical issues. His doctor told him that he may need to seek other employment. A witness testified to the hearing the doctor tell this to the claimant. The claimant has provided medical documents to the commission, and the employer testified the claimant did tell him about the issues. The claimant had good cause to quit. Additionally, since the claimant quit due to medical reasons, the employer's account should be protected from charge. Modify the AT, no voluntary leaving, no chargeback, MBI.
We should affirm the appeal tribunal decision. The claimant alleged that health issues caused him to resign. However, the claimant's medical documentation does not include a recommendation that the claimant quit his job, nor does it state that the claimant's job either caused or exacerbated the claimant's medical issues. Accordingly, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3198563, Commissioner Alvarez.
The decision is not supportable. The claimant is the only party to provide testimony in this case. The claimant has consistently provided that she completed her PIP without incident and that there was no issue following her PIP. The employer has failed to provide evidence of misconduct. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. In her fact-finding statement, the claimant admitted that she failed to communicate with one of her clients for 6 months. In its response to the claim, the employer corroborated this statement and noted that the claimant was discharged after the claimant's failure to communicate with the client resulted in loss of the account. Since these initial statements were provided closer in time to the job separation and they are consistent with each other, they provide the most credible account of the events which led to the claimant's job separation. Since the claimant failed to maintain contact with an account after being placed on a performance improvement plan, the claimant mismanaged her position of employment. We should affirm the AT decision, misconduct, no chargeback.
Affirm the AT misconduct, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez. That was the last pulled case for additional discussion on docket 40. You should have received the UI short form dissent list for docket 40.
I move we accept staff recommendations on the remaining UI cases on docket 40, except for those cases on which I am dissenting as reflected on the UI short form dissent list for docket 40.
I second the motion, except for those cases in which I'm dissenting as reflected on UI short form dissent list for docket 40.
40, and I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 40.
Motion passes with the exception of none.
Thank you. Proceeding to docket 41.
Case number 2611001, Commissioner Demerson.
The commission should conduct a rehearing in this case. The employer, although through its testimony and evidence submitted to the commission, clarified that they had offered various accommodations to assist the claimant with her medical needs. One possible accommodation noted was the claimant's ability to teach virtually. The hearing officer did not question the parties nor develop the record about this matter. Since the opportunity to work remotely in a setting suitable to the claimant was an acceptable accommodation in line with the claimant's medical needs, the hearing officer erred by failing to question the parties or develop the record about this issue. Hence, we should rehear this case to develop the record about whether the claimant was allowed to teach virtually.
I would agree to rehear.
Rehear.
We will rehear the case.
Case number 2626616, Commissioner Alvarez.
The AT decision should be modified. The claimant established good cause for the non-appearance at the AT2 hearing because he did not receive the notice of the telephone hearing. Likewise, the employer also established good cause for their non-appearance at the AT1 hearing due to non-receipt of the notice of telephone hearing. On the merits, the claimant was discharged for reasons other than misconduct connected with the work. The claimant was accused of failing to inform the employer of an oil leak in the truck he had driven after the truck's engine blew up. However, the claimant was not the driver of the truck at the time of the damage. Also, the claimant had made the employer aware of the truck's oil leak days before the incident, but nobody took measures to have the vehicle repaired. The claimant's actions on the final incident did not constitute mismanagement of his position of employment. Modify the AT, claimant had good cause for their non-appearance at the AT2, employer had good cause for their non-appearance at the AT1, no misconduct, chargeback, void, adequate response.
We should modify the appeal tribunal decision. First, I do not contest that the claimant established a good cause for missing the AT2 hearing. Second, I agree that the employer had good cause to miss the AT1 hearing. Concerning the job separation, the claimant received various warnings prior to his termination and was aware that his job was in jeopardy. Regarding the final incident, although the claimant noted that the employer's vehicle was low in oil, the claimant failed to properly follow up on the maintenance for the vehicle and thereafter performed an unauthorized route swap with another driver. This resulted in the driver using the vehicle, which caused extensive damage to the vehicle. Since the claimant was aware that his job was in jeopardy, but thereafter mismanaged his position of employment, his conduct constituted misconduct connected with the work. Hence, we should modify the AT decision. The claimant had good cause for missing the AT2 hearing. The employer had good cause for missing the AT1 hearing. Misconduct, no chargeback, sever the adequate employer response issue.
Modify the AT, claimant established good cause for AT2, employer established good cause for AT1, no misconduct, chargeback, void, adequate response.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2867796, Commissioner Demerson.
The appeal tribunal decision should be modified. Regarding good cause, the claimant stated that he did not receive the hearing packet and that his mail was checked every day. However, the claimant's testimony reveals that multiple people checked the mail at the claimant's address. The claimant was able to account for himself and one other individual regarding whether the hearing notice was received. Yet the claimant's sister-in-law was also mentioned, and whether she received the hearing notice is a mystery. As such, the claimant's testimony should be deemed as not having rebutted the presumption of receipt. As to the job separation, a finding of misconduct is supportable. The claimant broke a safety rule by speeding ahead of his foreman in violation of the employer's procedures. Safety rules are instituted to protect others from harm, danger, and/or injury, and as such, a violation of the same constitutes work-connected misconduct. We should therefore modify the AT decision. The claimant did not have good cause for his non-appearance. Misconduct, no chargeback, sever adequate employer response.
The AT decision should be reversed. The claimant did not appear for the AT1 hearing because he never received a notice of telephone hearing. The claimant did not have adequate notice of the hearing and therefore had good cause for the non-appearance. On the merits, the employer did not have firsthand testimony about the final incident. The employer alleged that the claimant was discharged for speeding, getting ahead of his foreman on the highway and arguing with his supervisor. The claimant credibly testified that he was driving the speed limit and got it behind the foreman when instructed to do so. While the employer claimed that the policy is to go 5 miles per hour under the speed limit, the claimant testified that he was only aware that he should travel at or under the speed limit. The claimant also testified that he did not argue with or even speak to the foreman regarding the final incident. Finally, the coworker who rode with the claimant was discharged at the same time as the claimant, which diminishes the credibility of the employer's contentions in this case. The employer failed to provide sufficient evidence to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, claimant had good cause for the non-appearance at AT1, no misconduct, chargeback, void, adequate response.
Reverse the AT, claimant established good cause for AT1, no misconduct, chargeback, void, adequate response.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2875196, Commissioner Alvarez.
The appeal tribunal decision is not supportable. While the claimant was unable to resume her previous occupation due to her health condition, the claimant was actively looking for other types of work that she was qualified to perform. The claimant's doctor's note was written in April of 2020 for the purpose of her not returning to her formal occupation, but it was not intended to prevent the claimant from all work. There is no evidence that the claimant's inability to resume her former occupation unduly limited the claimant's availability to accept other full-time work that she is qualified to perform. Reverse the appeal tribunal decision. Claimant was available for work beginning November 11, 2020. No overpayment, void waiver determination.
Agree with that. The AT decision is not supportable. The claimant gave credible testimony that despite her unavailability for work in a dental office, she is interested in and actively looking for other kinds of work. It goes without saying that there are countless positions in the Texas economy for which someone like the claimant would be qualified. The doctor's statement from 2 years ago is vague and without any meaningful value in the absence of specific context. The claimant has shown that she is and has been available for work. Accordingly, we should reverse the AT decision. The claimant is available for work. No overpayment, void the waiver ruling.
Affirm the AT. Claimant not available for it beginning November 1st, 2020, overpayment waiver denied. Short form dissent.
Thank you, sir.
Case number 2981847, Commissioner Alvarez.
The AT decision should be modified. The claimant had good cause for her non-appearance at the AT1 hearing since she did not receive the notice of the telephone hearing. On the merits, the claimant was subjected to severe harassment by a sergeant with supervisory authority over an extended period of time. She reported the harassment to HR, but no action was taken. On the final incident, she was again subjected to aggressive behavior when she argued with the claimant and then grabbed the bag that she was carrying. A lieutenant witnessed the incident, but again took no action. The claimant had good cause connected with the work to quit in response to these working conditions. Modify the AT, claimant had good cause for the non-appearance, no voluntary leaving, bill reimbursing employer, void adequate response.
We should modify the appeal tribunal decision. First, I do not contest the good cause issue. Concerning the job separation, the claimant quit due to dissatisfaction with her working conditions. Although the claimant made allegations of sexual harassment, the employer's investigation did not reveal instances of harassment nor evidence of an EEOC policy violation. Finally, the record shows that the claimant quit prior to addressing her concerns with HR or providing the employer a chance to remedy her dissatisfaction with the employer's working conditions. As such, the claimant quit without good cause connected with the work. Hence, we should modify the AT decision. The claimant had good cause for missing the AT1 hearing, voluntary leaving, reimbursing employer not billed, adequate employer response issue.
Modify the AT, claimant established good cause for AT1, voluntary leaving, reimbursing employer not billed, adequate employer response.
Just to clarify a detail, Mr. Chairman, did you want to rule on adequate response or sever it?
Would impose adequate employer response.
Okay, and I didn't hear you say the word sever. Did you want to rule directly on it or sever? It makes no difference in the result. We just need to know how to write the
This is
decision.
sever.
Okay, so the chairman's not severing.
Okay,
Um,
1 second. We're going to agree with the chairman.
Thank you very much.
Short form dissent.
Thank you, sir.
Case number 3011730, Commissioner Alvarez.
The AT decision on the timeliness should be reversed. After the claimant was held ineligible for PUA benefits, the claimant repeatedly contacted the commission about his non-payment of benefits. He was never informed about his appeal rights or that the determination at issue had held him ineligible. The claimant's late appeal was the result of misinformation from the commission representative. On the merits, the claimant became unemployed when the company he worked for shut down due to the pandemic. He was not able to return to work. His unemployment directly resulted from the pandemic, and he should be eligible for PUA. Reverse the AT, timely appeal, PUA eligible.
The AT decision is not supportable based on the information in the record. The claimant's late appeal contained allegations of potential misinformation concerning the need to appeal the initial determination, but it appears that the hearing officer did not ask the claimant any direct questions regarding those allegations. Accordingly, we should hold a rehearing to obtain specific testimony from the claimant about the timeliness of the appeal issue.
Rehearing.
We will rehear the case.
Case number 3020065, Commissioner Alvarez.
The decision is not supportable. The claimant was unable to attend the hearing because he was being held on a warrant. The claimant had tried to resolve the matter before the hearing and asked to call in from jail, but was denied. The claimant had good cause for missing the hearing. Reverse the AT, good cause, and resubmit.
We should modify the appeal tribunal decision concerning good cause. The claimant was denied bail after he used an unlicensed bail bonding company to secure bail. The record suggests that if the claimant had utilized a licensed bail bonding company, he could have timely received bail and thereafter attended the AT1 hearing. Since the claimant failed to show that he was prevented from attending the hearing due to circumstances beyond his control, the claimant did not have good cause for missing the AT1 hearing. Concerning the job separation, the claimant was terminated for engaging in a physical altercation with a coworker and thereafter withholding information from the employer when questioned about the incident. The record shows that the claimant, while wearing a t-shirt representing the employer, initiated an altercation where he verbally and physical assaulted a coworker. Since the claimant's action constituted misconduct, we should modify the AT decision. The claimant did not have good cause for missing the AT1 hearing. Misconduct, reimbursing employer not billed, sever the validity of claim and adequate response issues. Short inadequate response issues. I'll end it there.
Thank you.
Thank you.
Modify the AT. Claimant did not establish good cause for AT1. Misconduct, reimbursing employer not billed, severability of claim, and adequate response.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3037680, Commissioner Alvarez.
The appeal tribunal decision should be reversed. The claimant filed her initial claim with the effective date of February 7, 2021. A determination approved the claimant for benefits dated March 1st, 2021. Despite the employer filing a timely appeal to the determination on March 11, 2021, there was a sufficient delay in scheduling the hearing, which was not scheduled until the end of the claimant's benefit year on December 16, 2021. By this time, the claimant was not filing claims and had no reason to no reason to suspect that the employer was appealing her approval for benefits. The claimant left town for a family emergency to help her ill relative. As the claimant had no reason to expect a hearing packet from the commission, she did not have anyone screening her mail while she was out of town. The claimant was not in control over when the commission decided to schedule the hearing. The claimant should not be deprived of the ability to testify regarding her separation due to the delay in scheduling the hearing, which was beyond her control. The claimant established good cause for missing the hearing, and this case should be resubmitted for a summary of, should be resubmitted for a summary of the merits.
We should modify the appeal tribunal decision. Concerning good cause, the claimant did not receive the notice of hearing because she failed to make sufficient arrangements to receive the mail. Although the claimant alleged that she did not make arrangements because she was not expecting correspondence from the commission, this argument is flawed. The claimant, being current in her benefit year at the time of the AT1 hearing, was responsible for monitoring her mail for any correspondence relating to her claim. Since the claimant failed to establish that she was prevented from participating in the hearing due to circumstances beyond her control, the claimant did not have good cause for missing the AT1 hearing. Concerning the job separation, the claimant was aware of the employer's job requirement to submit her lesson plans in a timely manner. Claimant did not submit her lesson plans, although she was provided multiple extensions on her submission deadline. Since the claimant was instructed to prioritize submitting the lesson plan in a timely fashion, the claimant's refusal to adhere to the employer's specific instructions constituted mismanagement of her position of employment and was misconduct connected with the work. Hence, we should have modified the AT decision. The claimant did not have good cause for missing the AT1 hearing, misconduct, reimburse an employer not bill, sever the adequate employer response.
Reverse the AT, claim established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3038142, Commissioner Alvarez.
The decision is not correct. The claimant was not an employee of the entity named on the continued claim and was self-employed. There was no separation from work and the continued claim is void. Set aside the AT decision, void November 15, 2021 determinations, no work separation.
We should affirm the AT decision. The claimant elected to stop working for the employer due to his fear of contracting COVID-19 and because he had been approved for UI benefits through his initial claim separation. Since the record reflects that the claimant did not attempt to address his concerns about COVID-19 prior to quitting, the claimant did not establish a good cause connected with the work to quit. Hence, we should affirm the AT decision, voluntary leaving, overpayment of $6,420.
Void the continued claim, no overpayment.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3084864, Commissioner Alvarez.
The appeal tribunal decision should be reversed. At the time the hearing notice was mailed and the hearing was conducted, the claimant was on bed rest due to medical condition. The claimant was prevented from timely checking her mail due to her medical condition. Even if the claimant had received the notice in a timely manner, her medical condition would have prevented her from participating in the hearing. As such, we should find that the claimant has established good cause for missing the hearing and resubmit the case for a summary of the merits.
The appeal tribunal decision should be affirmed. The claimant's explanation for why she missed the appeal hearing did not contain specifics in terms of dates and when her mail could be checked. As such, the claimant has not provided testimony to establish she had good cause for a non-appearance. Regarding the job separation, the evidence available to the appeal tribunal establishes that the claimant quit when she refused to return to work. As such, the claimant quit without work-connected good cause. We should therefore affirm the AT decision. The claimant did not have good cause for her non-appearance, voluntary leaving, no chargeback.
Reverse the AT, claim established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3087285, Commissioner Demerson.
The appeal tribunal decision is fully supportable. The claimant was discharged for an incident at the employer salon during which the claimant screamed, yelled, and used profanity within earshot of coworkers and clients while speaking with her manager. Despite the employer's efforts to remove the claimant from the public spaces and instructing her to calm down, the claimant continued her unprofessional behavior. In addition to a firsthand description of the claimant's actions, the employer also provided written statements signed by two coworkers who were present during the final incident. Moreover, text messages between the claimant and coworkers corroborate the employer's account of events. Therefore, because the claimant behaved unprofessionally and inappropriately while at work, she mismanaged her position of employment. We should modify the AT decision, misconduct, no chargeback, sever the adequate employer response issue. Sever the adequate employer response.
The AT decision should be reversed. The employer contended that the claimant was discharged because she supposedly screamed and acted threatening at work. The employer's evidence was less than credible since they provided no specific information about the threatening statements allegedly made by the claimant. Moreover, an employer's witness clearly exaggerated the claimant's conduct when they asserted that the claimant acted in a threatening manner simply by standing up with her cell phone in her hand. The claimant has provided text messages, correspondence indicating one of the employer's witness statements might have been coerced. Finally, the employer's actions in cursing at the claimant, and putting her in an involuntary and indefinite leave when she had just suffered multiple deaths in her family would reasonably elicit a vocal and intense response, such as the claimant provided here. The employer did not establish misconduct by the claimant. Reverse the AT, no misconduct, chargeback, void adequate response.
Reverse the 18, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 3088853, Commissioner Alvarez.
The decision is not correct. The claimant was not an employee of the entity named on the continued claim and was self-employed. There was no separation from work and the continued claim is void. Set aside the AT, void November 5th, 2021 determinations, no work separation.
The appeal tribunal decision should be affirmed. The claimant filed his appeal beyond the applicable deadline to do so. This was the result of the claimant failing to notice the deadline for a timely appeal. There are no good cause exceptions to the timeliness rules. As such, the claimant's appeal was late and we should affirm the AT decision. Untimely claimant appeal, leave the underlying decision in full force and effect. Voluntary leaving, overpayment.
Set aside the AT, void continued claim, no overpayment, memo to investigate availability.
Short form dissent on my
Yes,
side.
sir. Thank you, sir.
Case number 3109507, Commissioner Demerson.
The appeal tribunal decision is supportable and should be modified only to sever the adequate employer response issue. Regarding good cause, the claimant misread the hearing notice and did not appear for the hearing. The latter does not constitute good cause for missing the appeal hearing per commission precedent. As to the job separation, the claimant was discharged for poor work performance. The claimant was tasked with monitoring an email box and ensuring that requests were processed within 24 hours. The employer testified that the claimant demonstrated the knowledge and understanding of how to do the job. However, the employer's side's response reveals that there were some emails that were not processed for more than 3 weeks after they had been submitted. With the expectation that emails be processed within 24 hours, a 3-week gap between receipt and processing indicates neglect, rather than working to the best of one's ability. Since the claimant did not have good cause for a non-appearance, the employer's testimony was uncontested and should be given the greatest weight. We should therefore modify the AT decision. The claimant did not have good cause for a non-appearance, misconduct, reimbursing employer not billed, sever adequate employer response.
I do not contest that the ruling that the claimant did not have good cause for a missing AT1 hearing. However, the available evidence establishes the claimant was discharged for reasons other than misconduct. Commission precedents holds that an individual's inability to meet the employer's standards cannot be deemed misconduct unless there is a clear evidence that the individuals demonstrated the ability to consistently meet the required standard. Here, the claimant was unable to meet the employer's standard for ordering medicine and was fired during her probationary period. Evidence has not been provided to clearly establish the claimant had the ability to meet the employer's standard. Modify the AT, no good cause, no misconduct, bill employer, void adequate response.
Modify the AT, claimant did not establish good cause for AT1, no misconduct, bill reimbursing employer, void adequate response.
Short form dissent.
Thank you, sir.
Thank you.
Case number 3115221, Commissioner Alvarez.
The appeal tribunal decision should be reversed. Prior to the pandemic, the claimant was working 50 hours a week due to the slowdown in the employer's business caused by COVID-19 pandemic. The claimant's hours were essentially cut in half, which caused a more than 20% reduction in his wages. The claimant continued to work for the employer in the hopes that his hours increased to pre-pandemic levels. However, the claimant's desire to continue working during the unprecedented pandemic should not be interpreted as an acceptance that his hours were permanently reduced, as the claimant was unable to know the long-term impact of the pandemic on the employer's business. The claimant's part-time work with the employer required him to work 6 days a week and hampered his ability to successfully search for full-time work. The claimant provided the employer with a month's notice of his intention to quit due to his need to search for full-time work. The employer's testimony acknowledged that they knew the claimant was seeking full-time work, which the employer could not offer due to the slowdown in their business. As such, commission should find that the claimant established good cause connected with the work for quitting when the reduction in the claimant's hours caused a significant reduction in the claimant's wages. Reverse the appeal tribunal decision, no voluntary leaving, no overpayment.
The appeal tribunal decision should be affirmed. The claimant quit because he was dissatisfied with the reduction in his work hours. However, the claimant worked under that reduction for over a year. As such, the claimant ratified the new schedule by continuing to work that schedule for over a year. Accordingly, the claimant's reduced hours should not be considered in the decision for this case. Since the claimant ratified his new working conditions and did not present any evidence that his working conditions were intolerable, he quit without work-connected good cause. Should therefore affirm the AT decision, voluntary leaving, overpayment.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3118129, Commissioner Demerson.
The appeal tribunal decision should be modified. First, the claimant filed a timely Rule 16 petition to reopen, and he had good cause for his non-appearance. As to the job separation, the review of the testimony from the parties reveals that the claimant had been on leave multiple times, with his most recent leave being on short-term disability. Ultimately, the claimant became separated from his job when the employer was unable to secure the required documentation needed to extend his leave. As such, the claimant should continue to be qualified for benefits, and the employer's account should be protected under medical separation analysis. We should therefore modify the AT decision, timely Rule 16 petition to reopen. The claimant had good cause for his non-appearance, no voluntary leaving, no chargeback, MVI.
Ms. Miller, I would agree with Commissioner Demerson.
We have a majority vote of timely Rule 16. Good cause has been established. No misconduct, no chargeback, MVI.
I agree.
Thank you. Unanimous decision.
Sure, can you read the vote on the no voluntary leaving?
For 3118129.
3118129.
Okay, my notes reflect no misconduct, no chargeback, MVI on the separation.
Right, and my vote was no voluntary leaving.
Oh. The majority vote is still to grant benefits to the claimant. Commissioner Demerson is putting it under a voluntary quit rationale. Commissioner Alvarez, you agreed with Commissioner Demerson. Do you still agree with that?
Yes, ma'am.
Okay, and do you still agree, sir? When I had stated it before, I had said it was a misconduct rationale.
Well, no, I don't agree, but it's the same net effect, so I'll go along with it.
Thank
It
you,
was
sir.
misconduct, but yeah.
Okay, so the majority vote is voluntary leaving on the separation. Yeah. Thank you. Thank you for clarifying.
Got it, thank you.
Case number 3140085, Commissioner Demerson.
The AT decision is not supportable based on the evidence currently available. The employer gave credible and consistent testimony that the company faxed a timely response to the notice of maximum potential chargeback in July 2020. Unfortunately, it had no documentation of the timely faxing of the response, and TWC did not receive such a document from the employer at the time alleged by the employer. Since TWC was still experiencing significant problems with the volume of claims, appeals, calls, faxes, and regular mail in July 2020, and the employer's phone records for that month would include evidence of faxes sent, we should hold a rehearing to obtain testimony and other evidence concerning the employer's fax records for the month in which the company allegedly faxed its protests.
We should affirm the appeal tribunal decision. The employer did not file a response to the notice of maximum potential chargeback dated July 6, 2020 until September 14, 2021, which was clearly after the response deadline on August 5th, 2020. The employer testified under oath that they received the notice of maximum potential chargeback during the response time period and faxed their response to the commission on July 20th, 2020. However, there is no evidence of the commission receiving the response allegedly sent on July 20th, 2020. The employer failed to offer any credible physical evidence specifically linked to the alleged timely response. We should affirm the appeal tribunal decision and find that the employer's response was late to the notice of maximum potential chargeback.
Reverse the AT, timely response to the NMPC resubmit.
We don't yet have a majority vote.
We resubmit. I agree with the chairman.
Thank you, sir.
Thank
We'll
you.
resubmit the case.
Case number 3169663, Commissioner Demerson.
We should reverse the appeal tribunal decision. Months before the governor's executive order was issued, the employer implemented a vaccine policy. The employer allowed for exemptions as required by law, but the claimant chose not to submit an exemption. Because the claimant failed to comply with the reasonable policy and was aware that compliance was a condition of continued employment, she was discharged under disqualifying circumstances. We should reverse the AT decision, misconduct, reimbursing employer not bill, adequate employer response. In the alternative, we should grant a rehearing in this case. In its appeal to the commission, the employer states that when hired, the claimant signed an employee comprehensive immunization plan, which required her to comply with CDC vaccine mandates. We should rehear this case to examine the employer's immunization policy and whether the claimant had agreed to comply and had been complying with this policy during her employment.
We should affirm the appeal tribunal decision. The employer's requirement to receive a COVID-19 vaccination by September 27, 2021 was a substantial change in the claimant's hiring agreement. While the employer offered employees the ability to apply for a medical or religious exemption, the claimant did not apply for an exemption because the employer did not offer a personal conscience exception, which was the exemption the claimant was seeking. The employer confirmed in their appeal to the commission that they made a decision not to offer a personal conscience exemption. As such, the claimant's failure to apply for an exemption or to be fully vaccinated by September 27, 2021 should not be considered misconduct connected with the work. The appeal tribunal decision should be affirmed. No misconduct, bill employer's reimbursement account.
Reverse AT, misconduct, reimbursing employer not billed, adequate employer response.
Short form of dissent.
Yes, sir, Commissioner Alvarez.
Case number 3174873, Commissioner Alvarez.
The decision is not correct. The claimant received a determination and attempted to contact TWC multiple times. Additionally, he went into the TWC office, but it was closed due to the pandemic. He was locked out of his account and unable to file online. He attempted to provide emails during the appeal deadline. The claimant's inability to file a timely appeal was due to technological issues and closed offices. As such, his appeal should be deemed timely. Regarding the earnings adjustments, the evidence shows the claimant was not rehired until December 7th, 2021. The wages in question were improperly added to his benefit week ending December 5th, 2021. The earnings adjustment should be reversed. The claimant had no wages for the benefit week ending December 5th, 2021. Reverse the AT, timely appeal, no earnings adjustment.
We should affirm the appeal tribunal decision. The claimant's appeal was not timely. As there are no good cause exceptions to the timeliness rules, we do not have jurisdiction to consider the underlying merits. We should affirm the AT decision. The claimant filed a late appeal, earnings adjustment overpayment of $482.
Affirm the AT, untimely claimant appeal, earnings adjustment overpayment.
Short form of dissent.
Yes, sir, Commissioner Alvarez.
Case number 3202423, Commissioner Demerson.
that we should modify the appeal tribunal decision. The claimant was discharged for excessive absences. Because the majority of the claimant's absences, including the final absence, were caused by the claimant's medical issues, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. We should modify the AT decision, no misconduct, no chargeback, MBI.
Ms. Miller, I would agree with Commissioner Demerson.
Affirm the AT, misconduct, no chargeback, short form dissent.
Thank you, sir. I have your short form dissent.
Case number 3208-836, Commissioner Demerson.
We should grant a rehearing in this case as the record has not been adequately developed. The claimant was discharged for using her own credit card information on a client transaction. According to the claimant, she acted on the owner's instructions. However, the employer was not questioned about this allegation or about the allegation that the employer had condoned such practices in the past. As such, we should rehear this case to properly develop the record on these issues.
The appeal tribunal decision should be affirmed. The claimant was discharged for an alleged policy violation after the employer's attempt to have the claimant resign for medical reasons was unsuccessful. While the owner testified that the claimant violated policy by using her personal debit card as a payment method to give a customer a discount, the owner did not deny that she directed the claimant to do so to retain the customer's business and reimburse the claimant for the payment. The claimant and her witness provided credible and persuasive testimony that it was a known practice that the claimant was to use her personal credit card to pay fees up to $50 to retain customers, and the owner would reimburse the claimant. The claimant's pay was not based on commissions, and there was no benefit to the claimant for making these payments. As the owner directed the claimant to commit the policy violation, and because the claimant was unaware that her actions were a policy violation, the claimant's actions did not rise to the level of misconduct connected with the work. Affirm the appeal tribunal decision. No misconduct chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. Commissioner Demerson.
Thank you.
Case number 3229496, Commissioner Alvarez.
The AT should be set aside. The claimant was self-employed as a driver and used the employer's app to obtain customers. In March 2022, the claimant temporarily ceased his self-employment because his vehicle did not allow him to continue working. Since he was self-employed, the claimant did not work in employment and did not have a work separation. Set aside the appeal tribunal decision, void the separation determination, no overpayment, no work separation.
We should affirm the appeal tribunal decision. The claimant stopped working for the employer due to her car being in the shop for several days. Because the claimant initiated the job separation for personal reasons and not for good cause connected with the work, the disqualification and the resulting overpayment are appropriate. We should affirm the AT decision, voluntary leaving, overpayment of $2,745.
Void the continued claim, no overpayment.
Short form dissent.
Yes, sir. Commissioner Demerson.
Case number 3231183, Commissioner Alvarez.
The AT decision is not supportable. The employer has offered no testimony or other evidence in this case. Per the claimant's statements, he pushed the coworker only after the coworker pushed him violently enough for the claimant to fall down. The claimant credibly stated that he was acting in self-defense. There was also no evidence that the coworker was also discharged as the claimant. The employer therefore failed to provide sufficient evidence of misconduct with the claimant, by the claimant, I should say. Therefore, the AT, reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. The claimant admitted that he engaged in a physical altercation with a coworker in violation of the employer's zero tolerance policy. While the claimant alleges that the coworker instigated the incident, the claimant did not have to become a willing participant. He had other non-violent alternatives available, such as staying on his forklift and reporting the coworker's actions to management. Because the claimant violated the employer's policy, we should affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir. Commissioner Alvarez. And that was the last unemployment insurance case pulled for docket 41. You should have received the UI short form dissent list for docket 41.
I move we accept staff recommendations on the remaining UI cases on docket 41, except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 41.
I second the motion except for those cases on which I am dissenting as reflected on UI short form dissent list for docket 41.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 41.
Motion passes with the exceptions noted.
Thank you. Proceeding to docket 42.
Case number 2815899, Commissioner Demerson.
That we should affirm the appeal tribunal decision. First, I do not contest the good cause issue. Concerning the job separation, the claimant quit based on her fear of contracting COVID-19 at the workplace. The claimant, although she had an immunocompromised husband, was neither advised by a doctor to quit nor quarantine. Additionally, the employer testified that they had implemented effective workplace safety rules to combat the spread of COVID. Since the record shows that the claimant's separation arose from a generalized fear of contracting COVID, and because continued work was available to the claimant at the time of her separation, we should affirm the AT decision. The claimant established a good cause for missing the AT1 hearing, voluntary leaving, no chargeback. In the alternative, if my fellow commissioners disagree, since the record suggests that the claimant's separation arose from the effects of COVID-19 pandemic, the claimant should be qualified for benefits and the employer's account should be protected from charge due to disaster. As such, we should modify the AT decision. The claimant established good cause for missing the AT1 hearing, no voluntary leaving, no chargeback, disaster.
Ms. Miller, I would agree with Commissioner Demerson. Claimant had good cause for the non-appearance AT1, no voluntary leaving, no chargeback due to disaster.
Affirm the AT, claimant established good cause for AT1, voluntary leaving, no chargeback.
The majority vote is pay and protect under disaster rationale.
I'm gonna agree with the chairman, Chair.
Okay, the majority vote is good cause has been established. VLXX, so no good cause for quitting. And CBOO.
So voluntary leaving and no chargeback.
Yes, sir.
That's fine. Okay.
Claimant disqualified, employers protected.
Short form and memo to UIA and OS to take a PUA claim backdated to when the claimant resigned.
Thank you. Have that. Mhm.
Case number 2842758, Commissioner Alvarez.
The decision is not supportable. The claimant's appeal period occurred during a time when there was a known IT issue which prevented individuals from filing some appeals through UBS. The claimant testified that she filed a timely appeal through UBS, of which there is no record. Given the known IT issue at the time, her appeal should be deemed timely. Regarding the merits, the claimant was forced to quit when she no longer had childcare due to the pandemic. No alternative was available, and no other individual could care for her children. The claimant is eligible for PUA. Reverse the AT, timely appeal, and PUA eligible beginning April 19, 2020.
The AT decision should be modified. The claimant did not offer any testimony or documentary evidence that would establish that she filed a timely appeal from the original determination. Although she testified about 4 different possible appeal filings, the first one would have been premature and the last 3 would have all been late. She did not have specific allegation of an appeal date that could be considered timely. However, TWC can assume jurisdiction over the PUA issue as of 14 days prior to her late appeal, and because her work separation was under circumstances that fall under the PUA program. She can be considered eligible for PUA benefits beginning February 21st, 2021.
Modify the AT, untimely claimant appeal, PUA not eligible from March 29, 2020 through February 20, 2021.
Commissioner Emerson, could you verify whether your vote agrees with the chairman's vote? I believe it does, but I want,
To fall under the PUA program, she can be considered eligible for PUA benefits beginning February 21st, 2021.
therefore not eligible from March 29th, 2020 through February 20th, 2021.
Let me clarify.
Yes, sir.
Actually, I'm going to read some dates into the record to make
Yes.
sure that we're all on the same
Yes, sir.
page there. So modifying the AT decisions, the claimant filed a late appeal that established jurisdiction beginning February 18th, 2021, ineligible for PUA March 29th, 2020 through February 20th, 2021. Eligible for PUA beginning February 21, 2021.
Yes, sir.
Okay.
I believe that corresponds with
It
your
does.
vote, with the exception that you didn't mention a date that jurisdiction was established. February 18th, 2021 is what Commissioner Demerson just stated.
I have no issue.
Okay, thank you very much.
Thank you.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2900035, Commissioner Alvarez.
The decision is not supportable. The claimant was struggling with a medical issue. After returning to work following the rest period recommended by a doctor, the claimant was still having issues. He then sought a second opinion out of the country. The doctor diagnosed the claimant with a medical issue, prescribed shots, and recommended a rest period of 22 days. The claimant has provided a doctor's note establishing his injury. Since the claimant quit to seek medical treatment, he has good cause connected with the work. Reverse AT, no voluntary leaving, no overpayment.
We should affirm the appeal tribunal decision. The claimant quit because he was dissatisfied with his doctor's medical diagnosis in the US. Although the claimant had medical insurance and was not prevented from seeking treatment within the US, the claimant quit to seek care for his home, from his home country. Since the claimant quit when he had continued available work, and because the claimant was not advised by his doctor to quit, the claimant did not establish good cause connected with the work or a separation. Hence, we should affirm the AT decision, voluntary leaving, overpayment of $5,350.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2992167, Commissioner Demerson.
The appeal tribunal decision should be affirmed on good cause and the case should be resubmitted. The employer clearly made a good faith effort to participate in the hearing, but mistakenly entered one number incorrectly. This is not an incident of a party knowing ahead of time that its phone is broken or sits idly by and does nothing to give the appearance that they are intent on participating in the hearing. Here, the employer was fully prepared to attend the appeal hearing. Given the circumstances of this case, it is entirely reasonable to conclude that the employer's mistake was inadvertent as opposed to intentional. Accidents happen, and such a mistake was outside of the employer's power to control. As such, we should affirm the AT decision on good cause. The employer had good cause for its non-appearance. Resubmit.
The employer failed to establish good cause for missing the hearing. The employer provided an incorrect phone number to the commission for the hearing, which was a mistake entirely within the employer's control. No good cause, late employer appeal, no misconduct, chargeback. However, if it is decided that the employer had good cause for missing the AT hearing, the employer failed to file timely appeal to the determination dated September 11, 2020. The employer's appeal was due on September 25th, 2020, but the employer filed the appeal on December 8, 2020, which was late. As such, the employer's appeal to the appeal tribunal was late. No misconduct, chargeback.
Affirm the AT, employer established good cause for AT1, resubmit.
We will resubmit this case.
Case number 3027943, Commissioner Alvarez.
The AT2 decision on the good cause issue is not supportable. The claimant missed the AT1 hearing because the notice of telephone hearing for the AT1 hearing never arrived at his address of record. The claimant's wife checked the mail at their residence when the claimant was not at home. The claimant credibly established that he was not given adequate notice of the AT1 hearing and therefore had good cause for his non-appearance. Reverse the AT2, claimant had good cause for their non-appearance at AT1 and resubmit for the merits testimony.
We should modify the appeal tribunal decision. Concerning good cause, the claimant missed the AT1 hearing because he did not check his mailbox on a regular basis. Since the claimant missed the hearing because he did not reliably check his mail, a circumstance within the claimant's power to control, the claimant did not establish good cause for missing the AT1 hearing. Concerning the job separation, the claimant was terminated when he violated the employer's safety policy by climbing and or crawling on top of customer boxes filled with medical supplies. The claimant's conduct endangered his safety and risked damage to the customer's property. Since the record shows that the claimant was aware of the employer's policy, but thereafter violated the policy by engaging in substandard safety acts, the claimant's conduct was mismanagement of his position of employment and was misconduct connected with the work. Hence, we should modify the AT decision. The claimant did not have good cause for missing the AT1 hearing, misconduct, no chargeback, sever adequate employer response.
Reverse the AT, claimant established good cause for AT1, resubmit.
We will resubmit this case.
Case number 3047064, Commissioner Alvarez.
The claimant registered her witness for the first hearing 33 minutes before the hearing start time. The claimant did not realize that she had needed to register her phone number because she assumed that the commission already had that information. The claimant's misreading of the hearing notice was a reasonable error, and she made a good faith effort to participate in the hearing by registering her witness for the hearing. As such, the claimant established good cause for missing the hearing. Reverse the appeal tribunal decision. The claimant had good cause for missing the hearing and resubmit the case for a summary of the merits from the second hearing.
We should affirm the appeal tribunal decision. The claimant did not register for the AT1 hearing because she misread the hearing packet. The claimant's misunderstanding of the hearing packet and her belief that she was not required to register did not provide her with good cause for missing the AT1 hearing. Concerning the job separation, the evidence shows that the claimant was fired for violation of the employer's fraternization policy and other policies that jeopardized the safety and well-being of the employer's clients. Hence, the claimant's actions constituted mismanagement of her position of employment and were misconduct connected with the work. Therefore, we should affirm the AT decision. The claimant did not have good cause for missing the AT1 hearing, misconduct, no chargeback.
Reverse the AT, claimant established good cause for AT1, resubmit.
We will resubmit this case.
Case number 3080655, Commissioner Demerson.
The AT decision is not supportable. The notice of maximum potential chargeback was sent out during the phase of the pandemic in which TWC claimants, employers, and the postal system were all overwhelmed, and the notice did not advise employers that they could handle the claim volume problem by protesting multiple claims at once. Importantly, the NMPC itself did not meet the needs of employers and the agency during the height of the pandemic, because even though the vast majority of claims and work separations were related to the pandemic, there was no way for employers to readily indicate that a particular work separation was caused specifically by the COVID-19 disaster. The employer responded to the NMPC as soon as practicable, once it learned of the possibility of chargeback protection and addressed its claim volume issues. Accordingly, we should reverse the AT decision in these companion cases. The employer filed a timely protest and resubmit on the merits of the chargeback issue.
The AT decision is correct. The employer filed a protest to the notice of maximum potential chargeback about a year and a half late. The employer now contends that he was unaware that the separations due to the pandemic were not chargeable. TWC publicized this information heavily during the pandemic. The employer chose to simply not respond or contact TWC about this matter until well after the deadline elapsed. The employer has not alleged a reason for the late response that is recognized as a basis in the commission rules to deem the protest timely. Affirm the AT late protest to the notice of maximum potential chargeback.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit this case.
Case number 3097188, Commissioner Alvarez.
The decision is not supportable. The claimant learned more complications with his partner's pregnancy, endangering his child's life, and he had to take her to the hospital. He notified his supervisor that he had to leave. He was later discharged for exceeding his attendance points for leaving to take his partner and unborn child to the hospital. The claimant's final absence was due to a medical issue and was not misconduct. The employer's account should be protected from charge. Modify the AT, valid claim, no misconduct, chargeback, MBI.
The appeal tribunal decision should be affirmed. I agree that the claimant filed a valid claim. As to the job separation, the claimant violated the employer's attendance policy by exceeding the number of allowable points thereunder. Moreover, the claimant's job was in jeopardy at the time of the final incident, and he did not provide any documentation to the employer that could have validated his absence. As such, the claimant's actions constituted work-connected misconduct. We should therefore affirm the AT decision, valid claim, misconduct, no chargeback.
Affirm the AT, valid claim, misconduct, no chargeback.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3098374, Commissioner Alvarez.
The decision is not correct. Regarding the timeliness of the complaint, correction of the claimant's appeal, TWC records show the claimant submitted a timely appeal. Regarding the job separation, the claimant was injured and taking paid medication. The side effects of the medication made him feel unable to work. The claimant reported the issue to management and was told he could stay or go. Since he was physically unable to work due to the medication, the claimant went home. The HR manager who testified for the employer stated, if he was feeling unable to work, he should have spoken to the manager. The claimant is the only party to provide firsthand testimony, and he states he did speak with the manager. Since the claimant's separation was the result of a medical issue, the claimant had good cause to quit. Reverse the AT, timely appeal, no voluntary leaving, void chargeback.
The appeal tribunal decision should be modified. First, the claimant's appeal should be deemed timely and the chargeback ruling should be voided. As to the job separation, the claimant left work due to feeling ill. However, he did not use the employer's timekeeping system to request time off. In addition, the employer stated that the claimant should have notified management of his issues instead of simply opting to walk off the job. As such, the claimant failed to take adequate steps to protect his job, and his quitting was without work-connected good cause. We should therefore modify the AT decision, untimely claimant appeal, leave the underlying decision in full force and effect, voluntary leaving, and void the chargeback ruling.
I'm sorry, could you please clarify your vote on timeliness?
Untimely claimant appeal. All right, so we should therefore modify the AT decision instead of untimely, timely claimant
Yes.
appeal.
Yes, sir. Thank you, sir.
Thank you.
And Mr. Chairman,
Modify the AT, timely claim and appeal, voluntary leaving, void chargeback.
Short form dissent.
thank you, Commissioner Alvarez.
Case number 3109893, Commissioner Demerson.
The AT decision is not supportable given the evidence currently in the record. The employer has given credible and consistent testimony that it did not receive the original notice, but its testimony is being discounted because it included a copy of the original NMPC with its late protest. That could mean that its testimony concerning non-receipt is in doubt, but it could also mean simply that it requested another copy of the notice and sent its late response after it received the copy. Since the relevant response period was in the middle of the worst of the pandemic overload times, it would be appropriate to hold a rehearing to allow the employer an opportunity to explain about the copy of the NMPC that it submitted with its late protests.
Ms. Miller, I would agree with the rehear.
We will rehear the case.
Case number 3131234, Commissioner Alvarez.
The AT should be modified. I agree that the AT that the claimant filed, I agree with the AT that the claimant filed a timely appeal from the determinations in this case. On the underlying PUA eligibility issue, the claimant lost her job with her last employer because her position was terminated due to the pandemic. Additionally, her child's school closed and she had no access to childcare beginning 3/15/20. She still did not have access to childcare during the summer of 2020 from 5/31/20 through 8/16/20. Moreover, her separation from employment remained the result of the pandemic, even after her position had previously had a tentative end date. The claimant should be held eligible for PUA beginning 3/15/20 with no PUA ineligibility. Modify the AT, timely claimant appeal, PUA eligible beginning 3/15/20, no PUA ineligibility.
The AT decision is partially supportable. I agree that the claimant's two appeals were timely. On the merits of the PUA issue, the claimant was eligible for PUA benefits from March 15th, 2020 through May 30th, 2020. I believe we need additional information regarding the availability of childcare during the school summer break of 2020 in the claimant's area. So we should hold a rehearing to obtain additional testimony from the claimant and from our agency on that issue. Concerning the period from August 16, 2020 through October 17, 2020. I agree that the claimant was eligible for PUA benefits during the time that in-person schooling for a child was unavailable. However, the claimant became ineligible for PUA benefits starting on October 18, 2020, when in-person schooling became available, but the claimant elected to keep her child at home. Accordingly, we should affirm the AT decision regarding the claimant's timely appeals and the claimant's eligibility for PUA benefits from March 15th through May 30th, 2020. Her eligibility from August 16, 2020 through October 17, 2020, and her ineligibility beginning October 18, 2020. We should hold a rehearing regarding the availability of childcare for the claimant's area from May 31st through August 15, 2020.
I concur with Commissioner Jones.
Yes, sir. What that means is, according to my notes, timely appeals, both appeals timely. The claimant is eligible for March 15th, 2020 through May 30th, 2020. The claimant is eligible from August 16th, 2020 through October 17th, 2020. Is not eligible beginning October 18th, 2020, and will conduct a rehearing to determine childcare availability for the dates 5/31 through 8/15, 2020. Okay.
Sure.
So no final decision yet. We'll still have a rehearing. Thank you, gentlemen.
Yeah.
Case number 3142535, Commissioner Alvarez.
The decision is correct. The employer picked up the claimant's company vehicle while he was out sick. After arriving on the job site, the employer discovered the toolbox was locked. They discharged the claimant alleging his locking of the toolbox, the locking of the truck toolbox was disabling company property. There is no evidence that the employer ever told the claimant he could not lock the toolbox. There is no evidence that the employer ever asked the claimant to unlock it or that the claimant refused to unlock it. Locking a truck toolbox so things are not stolen is common and sensible. The claimant's actions were reasonable. The claimant was discharged for reasons other than misconduct. Modify the AT, no misconduct, chargeback, void, adequate response.
The appeal tribunal decision should be modified. The claimant was given a specific instruction pertaining to his tools in the employer's company van. Nonetheless, the claimant disobeyed the instruction, and as a result, the employer was unable to use its own tools from its own toolbox. A reasonable person would know, or should know, that disobeying a direct work-related instruction from an employer, even without a warning or a policy, would result in termination of employment. This is especially the case where the instruction has to do with the orderly flow of work, which was deliberately interrupted by the claimant's actions. As such, misconduct connected with the work has been established. We should therefore modify the AT decision. Misconduct, no chargeback, adequate employer response.
Modify the AT, no misconduct, chargeback, void, adequate response.
Short form dissent.
Yes, sir. Commissioner Demerson.
Yeah.
Case number 3175483, Commissioner Alvarez.
The decision is not supportable. The claimant was being harassed at work and reported the issue to his supervisor. The supervisor spoke with the other individual, but the issue persisted. The claimant had expressed an interest in quitting over the issue, and his manager told him to make a decision. On October 27, 2021, the claimant provided a resignation letter with a separation date of January 10, 2022. The employer testified that for their own convenience, they separated the claimant after 2 weeks. In accordance with commission precedents, since the claimant provided notice in excess of 2 weeks and the employer accepted it early, the employer has the burden to establish misconduct. No evidence of misconduct has been presented in this case. Reverse AT, valid claim, no misconduct, chargeback. Even if the separation were analyzed as a quit, the claimant would still be entitled to benefits. The claimant was being harassed by an individual who the employer admits didn't have the authority to give the claimant any instructions. The claimant immediately reported the issue to the employer. Although the employer spoke with the individuals, the harassment continued and the employer did not take further actions to resolve this matter. Reverse the AT, valid claim, no voluntary leaving, chargeback.
We should affirm the appeal tribunal decision. I personally agree that the claimant filed a valid claim. As to the merits, the claimant initiated the job separation by submitting his resignation. The claimant had been discussing quitting his job with the supervisor for some time. When the supervisor sought clarification on this issue, the claimant, who had the option to continue working, chose to quit instead. Because the employer was addressing the claimant's complaints about a coworker and the claimant did not establish that his working conditions were intolerable, the claimant quit without good cause connected with the work. We should affirm the AT decision. The claimant filed a valid claim, voluntary leaving, no chargeback.
Modify the AT, valid claim, no misconduct, chargeback.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3191895, Commissioner Demerson.
We should modify the appeal tribunal decision. The claimant quit in part due to serious medical issues. Medical documentation in the record indicates that the claimant's doctor would not release her to return to work until she had a full medical workup related to chest pain. Under these circumstances, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. We should modify the AT decision, no voluntary leaving, no chargeback, MVI.
Ms. Miller, I would agree with Commissioner Demerson, no voluntary leaving, no chargeback, MDI.
Agreed.
Thank you. We have a unanimous decision.
Case number 3207683, Commissioner Alvarez.
The claimant testified that she was in the hospital unable to check her mail around the time of the hearing. She was reluctant to provide more details due to the advice from her attorney. In her appeal to the commission, the claimant provided more information on the good cause issue. She indicated that she had been in the hospital and was unable to return to her residence to check her mail because she was the victim of a serious assault. The claimant also provided a medical note indicating that she had been in the hospital before the hearing. Since the claimant was unable to return to her home to check her mail due to the risk to her personal safety, we should rehear this case to give the claimant an opportunity to further explain why she was unable to unable to appear at the first hearing. Rehear.
We should affirm the appeal tribunal decision. Regarding the good cause issue, the claimant testified that she was not at home nor checking the mail for a period of several weeks, including the weeks prior to the hearing. Although she now seems to indicate that she may have been in the hospital during the time away from home, this is inconsistent with her other statements. Because the claimant has not shown that she was prevented from participating in the hearing due to circumstances beyond her control, she did not establish good cause for her non-appearance. As to the job separation, the claimant was discharged for unprofessional and inappropriate behavior with a colleague. But because the claimant violated the employer's policy and her actions were not in the employer's best interest, the claimant mismanaged her position of employment. We should affirm the AT decision. The claimant did not have good cause for her non-appearance, misconduct.
Rehear.
We'll rehear the case.
Case number 3209040, Commissioner Alvarez.
The AT decision is not supportable. The claimant was discharged for absenteeism. She called her charge nurse to report her absence on the final incident. The record was not well developed, but it appears that the claimant was absent due to either personal illness or the illness of her minor child on the final incident. Her absence therefore did not constitute misconduct connected with the work. Reverse the AT, no misconduct, bill reimburse an employer. If my fellow commissioners do not agree to reverse the AT decision based on the available record, we should rehear this case to adequately develop the record as to the reason for the claimant's absence on the final incident.
All right, we should affirm the appeal tribunal decision. Claimant was placed on a final warning after several incidents of being absent without notice. In spite of this, 1 week after the warning, she called in absent and did not provide the employer a reason. Because the claimant continued to be absent after a final warning and failed to provide the employer a reason for her absence, the claimant mismanaged her position of employment. We should affirm the AT decision, misconduct, reimbursing employer, not bill.
Rehear.
We will rehear the case.
Case number 3215-179, Commissioner Alvarez.
The AT decision should be modified. The claimant was unable to work due to pain and swelling in his legs. The claimant has notified the commission that he has taken medication and is able to work despite his physical issue. Additionally, he is under the care of a physician who cleared the claimant to work and recommended that he find a better pair of boots. The ineligibility should be closed effective 4/16/2022.
We should affirm the appeal tribunal decision because the claimant initially stated that he was not able to work and has not provided any medical documentation establishing that he is able to work. We should affirm the AT decision, ability not eligible beginning March 20th, 2022.
Affirm the AT claimant not able to work beginning March 20th, 2022. Memo to investigate possible unreported earnings and potential incorrect LEU.
Ms. Miller, short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3243-287, Commissioner Alvarez.
The AT decision should be reversed. The claimant was demoted by the employer because they considered the claimant's performance as a store manager unsatisfactory. The evidence in the AT hearing did not establish that the claimant unsatisfactory performance rose to the level of misconduct. The employer decided to demote the claimant as an assistant manager, reduce her pay from $17.55 per hour to $15 per hour, relocate her to a store adding 20 miles to her commute, and place her under the supervision of a manager with whom there was a history of work conflicts. These changes altogether clearly constitute a substantial change in the hiring agreement. The claimant therefore had good cause connected with the work to quit. Reverse the AT, no voluntary leaving, chargeback, void adequate response.
We should modify the appeal tribunal decision. The claimant quit rather than accept the transfer to a different store location. Because the claimant had worked at this location in the past and her pay and duties would not have been substantially different from her original job duties, the claimant's quitting was without good cause connected with the work. We should therefore modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
Modify the AT voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3243-938, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant quit due to dissatisfaction with her working conditions. The claimant alleged that she was bullied and harassed by her supervisor. However, none of the activity that the claimant described rises to the level of bullying or harassment. Furthermore, based on the testimony of the parties, it is completely plausible to conclude that the claimant misidentified reasonable employer instructions as bullying, harassment, and creating a toxic work environment. In sum, the record reflects that the claimant simply did not like being told what to do and failed to establish that her working conditions were intolerable. Accordingly, the claimant quit without work-connected good cause. We should therefore reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The claimant was dissatisfied with the lead executive assistant's management practices and felt that the lead was assigning her too many additional duties after another employee quit and was bullying the claimant. The claimant had complained to the management for months about her concerns regarding the lead's behavior, but management took no steps to resolve the claimant's complaints. Since the employer had the opportunity to address the claimant's complaints and failed to take any action to resolve the claimant's concerns, the claimant quit with good cause connected with the work. The appeal tribunal decision should be affirmed. No voluntary leaving, chargeback.
Reverse the AT voluntary leaving, no chargeback, adequate employer response.
Short form of dissent.
Yes, sir, Commissioner Alvarez. And that was the last unemployment insurance case pulled for additional discussion on docket 42. You should have received the UI short form dissent list for docket 42.
I move we accept staff recommendations on the remaining UI cases on docket 42.
I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 42.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 42.
Motion passes with the exceptions noted. That brings us to the end of agenda items 3 through 7. Let's take a short break. So agenda item 8, final rules for 40 TAC chapters 800 and 805.
Good morning, Chair Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Cerna. For the record, Mahalia Baldini with the Workforce Development Division. On August 5th, 2022, the Commission approved proposed amendments to TWC rules in Chapter 800 entitled General Administration and Chapter 805 entitled Adult Education and Literacy. Chapter 800 proposed rules provide the Commission flexibility when deobligating AEL statewide funds and consider an AEL grant recipient's performance in the reallocation of those funds. Chapter 805 proposed rules provide modifications to the AEL requirements and provides updated terms and definitions. The proposed rule amendments were published in the Texas Register for a 30-day public comment period and no comments were received. Staff recommends adopting the amendments for Chapter 800 and Chapter 805 as outlined in your notebook materials. Should the commission adopt these rules, staff request the ability for minor non-substantial changes in order to conform to the publication requirements for the Texas Register. This concludes my presentation. I'm happy to answer any questions that you may have.
Comments or questions?
None here, Chairman.
None.
Is there a motion?
Chairman, I move that we adopt amendments to 40 TAC Chapter 800, 805 as recommended by staff.
Second.
Been moved and seconded. We're unanimous. Thank you. This is AEL Advisory Committee membership.
Good morning again. For the record, Mahalia Baldini, Workforce Development Division. Texas Labor Code, Chapter 315.005 and the Texas Administrative Code, Rule Chapter 805.43 require that the Texas Workforce Commission establish an Adult Education and Literacy Advisory Committee. The advisory committee must not be composed of more than 9 members and must include both a business representative as well as a local workforce development board representative. At this time, the committee does not have representation from the business community. As such, staff seeks direction on appointing Leslie Cantu, the Assistant Vice President of Administration for TWC, to fulfill this requirement to serve on the AEL Advisory Committee for a 2-year term that would end October of 2024. This concludes my remarks and I'm happy to answer any questions.
Comments or questions?
Molly, I love Leslie Cantu, so great choice.
Thank you.
Second, those thoughts, Leslie is coming to us. She also serves, I believe, as a board chair of our Alamo Workforce Solutions Office team as well. So excellent
She
choice.
does.
Excellent
Yes.
choice. Thank you.
Is there a motion?
I move that we appoint Leslie Cantu to serve on the AEL Advisory Committee for a 2-year term as discussed by staff.
Second.
Been moved and seconded. We're unanimous. Thank you.
Thank you.
This is Agenda item 10, final rules for 40 TAC Chapter 800 tax refund for wages paid to employee receiving financial assistance.
Good morning, Chairman, Commissioners, and Mr. Serna. For the record, Shanta Williams with the Workforce Development Division. Commissioners, before you today for your consideration and adoption are final rule amendments to Chapter 800, General Administration. In an open meeting on August 9th, 2022, the Commission approved proposed amendments to clarify the requirements and eligibility determination relating to tax refund for wages paid to employees receiving financial assistance as outlined in your notebook materials. The proposed rule amendments were published in the August 26, 2022 issue of the Texas Register for a 30-day public comment period with no comments received. Staff recommends adopting the amendments to Chapter 800 and requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation, and I'm available to answer any questions you may have.
Any comments or questions?
So nice to see you, Shanta.
Thank you.
None
Nice to
here.
be here.
Thank you.
Is there a motion?
I move that we approve and adopt final rules for Chapter 800 tax refund for wages paid to employees receiving financial assistance.
Second.
It's been moved and seconded. We're unanimous.
Thank you.
This is agenda item 11, board nominations.
Good morning, Chairman, Commissioners, and Mr. Serna. For the record, Cherie Dudley with the Workforce Development Division. Today for your consideration, we have workforce board nominations for Borderplex, Concho Valley, North Central Texas, Heart of Texas, Greater Dallas, Gulf Coast, Northeast Texas, Rural Capital Area, and South Plains. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Any questions or comments?
None here.
None here.
We never have any questions for her. Is there a motion?
I move to approve the board nominees for Borderplex, Concho Valley, North Central Texas, the Heart of Texas, Greater Dallas, Gulf Coast, Northeast Texas, Rural Capital Area, and South Plains.
Second.
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
All right, is there an executive director's report? Have what? Oh, we sure do. I skipped ahead.
Chris.
I was trying to somehow put that out of my mind. Agenda item 12, estimated unemployment trust fund balance report to the governor and legislative leadership. It's a good report too. I don't know why. I would have done that. It is, no, not ish. It's an important issue. We don't want any ranges here.
Yes. Morning, Chairman, Commissioners, Mr. Senator. For the record, Chris Nelson, Chief Financial Officer. Before you is the final kind of projection for 2022, and it's very close to the actuals that will be computed as of October 1st. And I'll walk through the document and kind of highlight recap what happened in 2022. So in October 1st, 2021, we started with a $5.8 billion deficit. We paid out almost $2.6 billion we collected $2.6 billion in remittances from employers. But we also received $6.9 billion in SB8 ARPA funds to help replenish the trust fund. That leaves basically a $2.1 billion trust fund balance as of October 1st, 2022. In the past couple of years, you'll be reminded that, we brought before discussion papers for the commission to contemplate adjusting the deficit tax and replenishment tax. With the trust fund balance at 2.1 billion, there is no need for that. We're working right now with the unemployment insurance folks to provide them the total benefits paid ending September 30th. That'll be used to calculate the normal tax rates. That's just happens on an annual basis, but there should not be any reason for a commission action item. It'll just be whatever the rates are calculated based off employer experience rates. One other thing to note, couple other things to note is on 3.04, at the time this report was created, it wasn't done yet, but we did transfer because we were above the floor. The floor we computed at 1.285 billion. Because we were above the floor on September 1st and projected to be October 1st, we do transfer from the ETI fund 19.9 million from that fund to fund the skills appropriation. Doesn't mean we double the skills appropriation. The regular general revenue we receive just goes back to the controller's office, but the ETIA fund does fund the skills appropriation in those years where we're above the trust fund. And so when I report the next quarter, you'll see that reflected in the 2022 column. Another thing to note is right now we don't have any data on the non-LAU employers and the potential for reversal of chargebacks. We're working with unemployment insurance now. Hopefully in probably December, I'll start bringing projections for the end of 2023. We're hoping to be able to quantify what that impact would be and have that reflective of any projections we do hopefully in December. So right now we don't have any information on what the impact would be, but in the future reports, we should have something on that. That was all I had. I'd be happy to answer any questions.
Any comments or questions?
None here.
None.
Thank you. I'd also like to just note that in the audience is Antonia Garcia and Giovanni Lopez. They are two high school seniors, and they are job shadowing me and hopefully future business majors, major accounting and business. And so they are job shadowing me today. And hopefully I won't turn them into the healthcare profession.
Make some time to come by my office so I can tell you what he really does do. You would, all right. Do we need a motion on this, Chris?
No, it's just informational.
Thank you very much.
Thank you, buddy.
No, but seriously, like sometime this afternoon, stop by. I've got a lot to share. All right, Mr. Cerna, I think I accomplished the whole agenda at this point. Is there?
Yes, sir.
executive director's report?
And I have no executive director's report.
Oh.
I'm not gonna prolong this meeting.
So much suspense. And is there any other order of business come before the commission?
Chairman, I'd like to introduce to everyone a new attorney that's joined our staff, Holly Aspen, who's joining us. Holly, if you could stand. Thank you she's been filling in for a couple of, I guess, almost a couple of years now. And so we're excited that she finally applied for the position that was vacant. So we're glad to have her. So Holly, welcome aboard.
Chairman, a number of things real quick. Chris, what high school are they from? I don't know if I missed that. Harmony Science Academy. We're glad to have you guys here. A couple of quick things. We've been working out across the state, and just a number of things I just want to share and highlight. Had an opportunity to go to Temple, Texas, with Commissioner Alvarez and McLean. We had a rehireability ceremony there. Susan Thomas with the local board joined us at that activity, and her and her team very, very well done. We also had an opportunity to be in Nacogdoches, Texas, and I'm sharing this because of the feedback I want you to know that Senator Nichols really appreciated the work that the agency was doing, shared those comments publicly about his support of TWC. He was there with Representative Trent Arby, Chairman, and also Hardy as well. And they recognized James White and a lot of positive attributes about what the Workforce Commission has been doing and the like. We were there at the request of Nancy Wyndham, and I was on the panel with Robert Allen and Adriana Cruz, talking about economic development and workforce and the like. And Mark Durant, our local Workforce Solutions office team, was there as well. I wanted to also just say thanks to Julia and her team. We just recently completed our TCEs across the state, put a number of those things on. That work doesn't take place without the hard work of my team, but also the team that Julia and her team being there with smiles with the number of requests that we have. And so we continue to appreciate the work that they're doing there as well. And lastly, a couple of things, our Texas Interns Unite event, we were in Dallas with Y Texas, and Lori Larray and Judy McDonald, the boards, again, the boots on the ground for all of our activities, were very supportive of those efforts. And White Cane Day was phenomenal with Cheryl Fuller and her team, and appreciate what they're doing for employers that are out there. But that particular day was one of special interest to me, and really appreciated the opportunity to participate in that activity once again. Mr. Chairman, that's all that I have to say.
All right, thank you. Is there a motion to adjourn?
I move that we adjourn.
Second that motion.
It's been moved and seconded to adjourn, and we're adjourned.